All right, ladies and gentlemen, welcome and thank you for coming to the WISL-sponsored plenary event, which is Real Space, Real Law, and Real Progress. For those of you who have just entered the room, the format of this particular plenary is going to follow those that we've had in the past that we found to be fairly successful, which is not really a presentation-style plenary, but more of a conversation. So I've encouraged you to come as close as you can. Don't be shy. Don't be on the far reaches of the galaxy. We want to have a galactic center discussion here, and something that becomes dynamic, hopefully, between our revered speakers here and you, the audience. We have a very exciting topic that I think will reveal itself and its implications it's not something that we normally think about unless we're lawyers, space lawyers in particular, every day, but it's something that really has impact on the future of our common interest, which is space exploration. My name is Bob Richards, and I'm the CEO of Odyssey Moon. I'm one of the founders of the International Space University, where we care about these subjects very much. And I'm pitch hitting today for Mr. Chris Stott, who was scheduled to be here, but unfortunately has been delayed by a atmospheric phenomena called Hurricane Ike, which unfortunately his home in Houston was at ground zero, and he's delayed in trying to dig out of that mess in Houston. So Chris can't be with us today, but I'm going to try to do my best to fill his capable shoes of chairing these sessions in the past. I want to thank very much the International Institute of Space Law for coordinating and pulling this together, particularly Tanya. Are you in the audience? Thank you very much for pulling this together. And we have in the next hour, we're going to introduce our speakers. We're going to get them to address a particular topic. And then we're not going to have any formally prepared questions. As I say, it's much more of a conversation that we'd like to induce. We have Renee with the microphone here, that if you have any questions that are spontaneous, put up your hand, and we'll bring you into the conversation. And we don't know where this is going to go, but that's part of the fun, is we hope that this is going to go in directions that we can't anticipate, and we'll have a real dialogue and exchange of values and create some new ideas, and hopefully go away from this session with a broader understanding of how space is a reality and how law and is really important for what we want to see happen today, and more particularly what we want to see happen tomorrow. So with that, let me introduce our panelists, which I thank you all for being here. Starting from the far right, Dr. Walter Peters, the Dean of the International Space University, and also the International Institute of Space Commerce, which we will be opening this coming weekend at the Isle of Man. Very proud of that affiliation. Walter will be speaking to us from his perspective, academics and business-wise, about our question today. Next, we have Clayton Mowry, President of Arianespace, who's joined us from the United States. And prior to his current position, Clay was the head of the Satellite Association of the United States, so I think has a lot of experience in dealing with some of these law questions and policy questions. To Clay's left, your right, is Dr. Christine Sallerberger, who is Vice President of MDA Space Missions, Canada's largest space company, Vice President and Director of Space Exploration. And I'm also proud to say that Chris is Vice Chairman of the International Space University and also a Director of Odyssey Moon. Thank you for coming, Chris. Next, we have Axel Cartier, who is with Excalibur Almaz, the General Counsel, a real lawyer. And you'll notice that we do have a mix of real lawyers and people who are trying to work within the legal framework to do real business and real policy, real academics, and real government. Next, we have Tom Shelley, who is the Vice President Marketing of Space Adventures. And Space Adventures, as you know, is the private sector firm that has put all the private astronauts into space, and has been doing that for a long time. So they really have been groundbreaking and breaking rules and making rules, I guess, in order to formulate a brand new marketplace in the world. So panelists, what I wanted to present and just to get the conversation going. And again, a very dynamic one, so it's not presentation form, but more of a conversation with respect to the speaker at the moment, and with a dynamic, hopefully, with the audience who may have spontaneous questions and points to make. What I wanted to ask each of you to comment on, first introduce a little bit more than what I've introduced of what you do in the space industry, and how space law and policy impacts your segment of the industry, what it means to you every day as you try to do what you're doing today. And talk about how you see that progressing over time. And over time, I'd say, let's say the next 5 to 10 years. Where are we on common footing? Where are we stable in this framework? And where are we uncertain? And what is the trend over the next 5 to 10 years? Is it getting more stable or less stable? And is that good or bad? And let's get the conversation going around that. And then if we can get that to a point that we can talk about what the gaps are in the future, that would be one of the things I'd like to come to conclusion with in this discussion, is to identify and see if we can find any common denominators from all the different perspectives of where law and policy needs to be addressed or unaddressed, as the case may be, to help fulfill the future that we all want to see. So perhaps I could ask Walter Peters to start to address that.
Yeah, it seems it's working. Well, I'm not representing industry, but I think we have the same problematic also in education. We are trying to educate a new generation of space leaders, and where we're also facing is that we have this hybrid situation. Traditionally, everything was stemming from a sort of governmental perspective. So you have to teach them the Outer Space Treaty, you have to teach them the treaties, but at the same time you have to warn them that the world is changing. These treaties, they were all written and developed at a time when there was a sort of idealistic thinking about space. I'm not saying that they are anti-commercial, I wouldn't go that far, but the world has changed. So we're sitting with the same problematic, I think, like everybody in industry. What do we do about it? What do we teach our students? Do we tell them that Outer Space Treaty will stay like that the next 500 years? Certainly not. Because if you look at the new space report, 64% of the space in America is commercial at the moment. So we're sitting with this sort of hybrid transition. Changing the Outer Space Treaty? Virtually impossible, probably. We don't have the right atmosphere at the moment. We don't have this sort of idealistic atmosphere. So what do we put in place? What do we tell our students what's going to be the regulatory framework within 10 years? World Trade Organization or anything else? So this is the point we are facing at it, but I'm pretty sure my friends of industry have more day-to-day problems with it. The concept of a launching state, is this still a concept that is going to stand? My personal opinion, not. But who is going to replace it and how are we going to replace it? And if I say launching state, I think I can automatically transfer to somebody who's daily involved in that, our colleagues of Arianespace.
Thank you. Is this coming through? Thank you, Walter. Yeah, we deal with it on a day-to-day basis. I mean, for us, it's not only law, it's policy and regulation, because it's the laws, how they're implemented, how the policy is set. And we're launching Arianespace, as I'm sure most of you know, we're the largest commercial launch services provider in the world. We launch everything from ATVs to the space station to commercial satellites to Earth observation satellites, Earth escape missions like Rosetta, the comet chasing mission. So we're providing services across the spectrum to ESA, to national space agencies, and to commercial satellite operators around the world. And we work under a number of these frameworks, the risk liability sharing regimes, the export control regulations that come out of the United States, the U.S. law and policy regulating what we can launch, how we can access certain markets for launch services in the United States. And a lot of this is coming along in terms of what's going to be the future for international cooperation in space. Heretofore, there's been some very let's say a strict view, I think, on the side of the United States in terms of the exploration architecture moving forward. How that's going to be viewed in a new administration with a new Congress, it'll be interesting to see whether or not internationals will be allowed into that, what's called the critical path, whether or not there could be some cooperation, industry cooperation across the Atlantic. renewal of the transatlantic partnership. There was a new space law that was recently passed in France, and how that affects the liability regime. And as Walter mentioned, who's the actual launching state? We bring Soyuz, the Soyuz rocket from Samara, from Russia, down to French Guiana, and we start providing commercial services and services to space agencies on a Soyuz Russian-built vehicle launched from French soil in French Guiana from a site that's owned by the European Space Agency. So a bit of a complex issue, but one that impacts us day to day. So we try to work within those regimes and policies and regulations to understand them, to make sure that we can continue to do business. Obviously, we continue to do business. In the past 12-month period from August of 07 to August of 08, we did 9 launches of the Ariane 5 vehicle. We placed 17 satellites in orbit, plus the ATV. So clearly, we find a way to work within these regimes. But it's not always easy, and it's something we have to focus on in day-to-day. Pass it on there.
Yeah. I very much agree with what Clay said. Really, I think the answer to your question, Bob, is in 2 parts. There's the here and now. Space is an international business. We need to deal with those. We need to deal with those current laws and regulations. You mentioned the ITARs. Clay, that's definitely something we as a company based in Canada but with significant operations in the U.S. and here in the U.K. Need to be dealing with every day. So things like even transferring technology between different divisions of the company isn't altogether obvious without getting special permissions if we have to cross those national lines. How we service customers, how we allocate people to work on jobs, because certain customers have national laws where citizens of certain countries cannot have access to that program, and so we need to assure that although those people might be working in a different country, that all the laws are being respected both in the country where they're working and in the laws of the customer country. And so that's a bit of I think the day-to-day business. And in the case of the U.S., and the U.S. is a very large part, of course, of the space market for most companies in the space world. In the case of MDA, we've gone by establishing a significant presence in the U.S. and putting it behind a special security agreement that has a blessing from the State Department, the American Department of Defense, and can operate as a true U.S. company, which is good because it can operate as a U.S. company without any restrictions, but as a consequence of that, there's a further distance between the parent company and the subsidiary that way, and we need to respect certain laws there. So those are the kind of things I think we're dealing with today. If one takes a step back, though, and perhaps this is maybe even more of interest along the lines perhaps where you'd like to go, Bob, if we look to the future, there are really a lot of question marks. You know, Walter has mentioned the Outer Space Treaty. It really didn't foresee a lot of the things we're thinking about today. MDA is a company that's very focused on commercial space. So you mentioned Odyssey Moon. We're the prime contractor for Odyssey Moon. We're doing a number of other commercially funded activities in deep space. And so if one wanted to, for example, go mine an asteroid in deep space, how do you have the legal right to own what you would bring back from an asteroid, for example? This wasn't envisioned. This commercial world of space really didn't exist when those treaties were put together. It was really all focused on the governments and the rules. And so I think this is a direction that we really, as a space community, need to be focusing on. Perhaps my lawyer colleagues here have some thoughts as well.
Well, first, I'm just going to say a few words about our company, really a few words, because we're not completely public yet. But Excalibur Arms Limited, it looks like I'm a general counsel of all Europe, but I'm actually general counsel for our company called Excalibur Arms. And we have a private commercial orbital spaceflight program. And stay tuned with that. I can't say so much about it, but what I can say is that we are registered on the Isle of Man, and for that we're very lucky because we obviously suffer a little bit less from ITAR, but we do unfortunately have to go through some of the ITAR aspects. But what is really important for us as a company is the constant search for the need of commercial risk reduction and states are really much more listening to what the commercial companies are asking for. And we've been very lucky because the UK Outer Space Act, the UK government is trying now to amend it and to make it extremely, to help businesses flourish under all the different economic activities that are taking place today. They do realize that they cannot afford anymore not to have companies intervene as real key players. So they do ask our company to provide some suggestions to help moving forward and really have a healthy commercial environment in space. And we propose some changes and hopefully will be taken in. For example, you're looking at liability and responsibility we like to separate it in law, but all you have to know is that it only falls on states right now under the article, under the Outer Space Treaty, and the Liability Convention. So it makes it very impracticable sometimes for states and for us. So we have to work together, and with that, again, we're very lucky as an Isle of Man company and to work with the UK because they've been extremely proactive, and we're hoping to be able to tell you more soon. But I agree with Professor, of course I agree with everyone here, but it is extremely hard because I'm also I'm a lecturer in space law. It's hard to teach the students what to do with the Outer Space Treaty these days. Is it worth criticizing it all over again? Well, possibly not, because to change it again, to modify, to come up with another space convention would be maybe a very good idea, but it would take ages, and it's probably not the best approach. So let's take what we have, let's amend what we can, and let's move on with what is possible. And I think, we're only the only company that can do that. So, and with the help of the states, but it's probably going to, we think it's going to work. So with a few amendments, I think, of the UK Outer Space Act, at least for us, we're going to be able to do a lot more in full cooperation with the UK, which becomes important because, again, they are the launching state at some point, and they will have, internationally speaking, as of today, the full responsibility and liability, whereas to some extent we don't. So the cooperation is needed there, and it's happening. So we're not too unhappy, actually.
Very good. My name's Tom Shelley. I'm with Space Adventures, and for those of you who don't know, we're responsible for so far sending 5 private citizens to the International Space Station, and for that we are considered by many essentially as sort of rule twisters, rule breakers, the renegades. And certainly as far as our orbital spaceflight program is concerned, from the outset we ran into barriers because the original treaties for the International Space Station had no provision for a private citizen going there, even as an agent, if you like, of one of the key partners being the Russians. So that presented us with some barriers to begin with, but thankfully we had the Russians on our side and were able to get over those, and now NASA is firmly a very key supporter of what we do. But other than that, regulations don't have, and laws don't have a tremendous impact on our business because we are not an operator. We are not actually the entity responsible for sending the vehicle into space. So we're largely an agent. So for that side of our business at the moment, there is very limited impact. As that business continues to grow, I think there'll be further implications. Elon Musk and the success of his Falcon launch the last few days obviously brings the Dragon project a little bit closer, one hopes, and there's obviously commercial implications there in what he's trying to do. Similarly with Bob Bigelow and his efforts to create a private space station. What implications is that going to have on some of the laws going forward, and how are the various different players within that field going to be regulated, if at all? Do they need to be? Certainly from our perspective, as an entrepreneurial company, the less regulation you have to deal with, the better. And I'm sure that goes for a lot of the people in the audience as well. And to put that in a little bit of perspective, I'll talk about a different aspect of our business, which is our zero gravity operation. Space Adventures recently acquired Zero Gravity Corporation. The two companies for many years have been very close. Zero Gravity, for those of you who are not aware, Zero Gravity Corp is a U.S. company that owns and operates a Boeing 727, and we provide weightless flights to the public for kicks, you know, just for fun. But we also provide flights to NASA. We have recently completed our first round of science experiment flights for NASA. But that operation took 11 years to get licensed by the FAA, from the date of first application to the date of first flight. And this was for an activity that was already being conducted by NASA within the same airspace. So this is just for a private organization to get a license to operate. That's an extraordinarily long time for a company to be investing in a program. And if that is a track record for what's going to happen in the future, you've got to hope it's not the case, because otherwise it's just going to stifle innovation and creativity.
In each of our sectors, we have to deal with every day. The Odyssey Moon is a venture, for instance, that is looking a magnitude beyond where most of the economic activity of space is right now, which is really very close to the Earth, isn't it? Thank you very much. So I think we've established we're looking at a private sector mission to the moon. And space is really pushing the boundaries even further daily activities. And friend of ours, Andy Aldrin, just pointed out to me during lunch that there's a T-shirt that he has that he enjoys that says that where explorers go, lawyers follow. And I think we're identifying that in many ways the commercial and the private sector is beginning to push the boundaries of, let's say, common sensibility. Even though we're talking about a space law, there really isn't there is no such thing as really space law. There's nothing that governs the activity of individuals other than the sovereign under which they were born. That's where and it's really it's the international treaties that were formulated mostly in the 60s that are the only framework that currently exists that we can say, well, is there any stable ground here at all where we can agree? It's been pointed out that the Outer Space Treaty has been mentioned by most of the speakers here, is really the only current framework which was written in another time, right, with other sensibilities and priorities, and in no way anticipated the private sector, for instance, explorers from commercial initiatives going out and doing things in space. And so those are precedents that when you get there as a private explorer, there is no framework that says whether you can or can't do it. Sometimes it's guided by your own sense of responsibility. So if we could think in the sense of the increase of Earth's economic sphere over the next 5 to 10 years from low Earth orbit out to the moon and maybe even beyond, how do each of you see that impacting your industry? And does that mean we're going to be on firmer ground or less firm ground? What's that going to mean to you as Earth's activity as human beings expand? It could be robotically and it could be with human beings, because what we do robotically is really an extension of what we do as humans. How does that future economic sphere look to you from each of your perspectives? And then maybe we could open it up, and I'd like to get some feedback from the audiences to expand the question. Perhaps I could pass the question back to you, Walter, because I saw you nodding at the Outer Space Treaty there being maybe an artifact from the past that should be revisited but not discarded.
I wouldn't go that far. I think it has its charms. Let's be very honest. It is something which has been put up idealistically. I had once had the privilege to talk to one of the people who drafted it, a Russian lawyer, Virechin. And when I asked him about his business impact, which we're talking about, he innocently and correctly said, at that moment we didn't even think about. There was even no thought in the world that a non-government would do something in space. Now, times have changed, but it's there. Trying to substitute it, no. I think I would keep it. I mean, it's nice. It's a nice framework. It's a nice philosophical, idealistic framework, but we may have to supplement it. And to supplement it, I think we have to go over to another type of people to think about, which is exactly as our learned colleague said, maybe we have to talk to business people. Let them think about and for instance, one of the ways which I see is Axel already mentioned the Isle of Man, and you also mentioned it, Bob. maybe we need a few people, like the institute that is being established at the Isle of Man, to think out of the box, new ideas, come up with something which is for the next few years, and then make sure that it is being put in implementing agreements, one way or another. Be it under World Trade Organization, be it under WTO, be it under... But let's have the two living together. In general, this is also the basis of a PPP, public-private partnership. Industry knows better where the money is going to come from the next 10, 15, 20 years. So let them say what they think the developments are, and then adapt ourselves to facilitate them to make money in the coming few years. But let them express first their needs, and then try to work that into an agreement.
Axel, maybe I could pass that point to you. As the lawyer on the panel here, if a smart bunch of people got together and identified how to close some gaps in such an illustrious facility as the International Institute of Space Commerce at the Isle of Man, how would that actually progress and become something that would be recognized internationally as an amendment, or what is the process and how does that happen?
For us, again, for my company, it's quite easy in a sense of we're quite close to the regulators. So because we wanted to be close to regulators, and they gave us the floor. I mean, they really asked it. So not every state is that way, but I think it's getting there. And I'm also, I wouldn't say I'm in love with the space treaties. I wouldn't say that, but I think we can be thankful to the work has been done, because the COPUOS, the Outer Space Treaty. The Committee for the Peaceful Use of Outer Space, which actually is back then the peaceful use of outer space. The text. So sometimes you have translations like the peace-loving nations, which of course seems extremely old-fashioned and ridiculous. But the work has been done there has been incredible, and the COPUOS is still working today very hard. We have two subcommittees. That's one legal, the other technical, and they're doing an incredible job. Now, of course, not everything can be done in a couple of years, but these people are there, and some here today are members of a COPUOS. They actually work as well with the industry. They do ask questions. The industry is also an observer. The ISU is actually an observer there, and a lot of team projects that are happening during the summer sessions of the International Space University are presented at the COPUOS, and they do listen a great deal to it. So for us to do, I think the best way is really to keep up with the law as it is, and the law as what you want it to bring, and to actually say what's wrong, tell the gaps exactly at the right people, the people that can change things, as regulators. Nobody else. I mean, the regulators can do that. The parliaments do that. I mean, it's not, it's however attractive a business is, you have to sell your product to those who can actually make it legal, because you do make it legal. And also lawyers have to work with engineers, and I enjoy it immensely, but some of my colleagues stay in their lawyers group, which is a big mistake, really do work with engineers, because they know the real questions, and you get to ask the right questions, because the question is not anymore, can we go on the moon and can we own anything on the moon? The question is how to deal with what we bring back from the moon at some point, and have all the sets of instruments to actually make every nation enjoy the benefits from it. So I think the only way to make it in a shorter version, to just really tackle the regulators and convince them you have a case. And if they tell you don't, fair enough, come back. Keep on banging on their doors, because you need to have it out there, because it is a real, it's really not out there, it's really here, down there we're talking about. So that would be my maybe too practical perhaps, but that's
Chris, I think you had a point to follow on.
Perhaps being more practical. I didn't quite agree with what you said before about the Outer Space Treaty being the only legal issue that companies had to deal with. And as a company, we have a whole team of lawyers and legal specialists. I can assure you they spend very little time worrying about the Outer Space Treaty. They spend their time worrying about making sure they're following, all their contracts are on the right side of the various national laws. And there are big impacts to that, even on commercial business. And I give you an example of that. We were approached by a a group of investors in the U.S. U.S. capital wanted us to do some space activities for them. And they said, please do this project for us. And by the way, the reason we're coming to you, to your Canadian offices, is because you're outside the ITAR zone, and we want you not to use any U.S. technology when you do this, because our end customers are international, and we don't want to be burdened with ITAR regulations, which it almost seems a distortion of what's going on, that you have U.S. money going outside the U.S. to try and achieve some activities in space. And there's a lot of other examples of how both companies inside the U.S. and outside are hindered by that particular set of regulations. And I'm not commenting on whether they're good or bad. There's good reasons why they're there. But the impact of those regulations, which are really made to restrict trade in arms, are having profound implications on how companies do their business, where they do their business, and how they set it up. And that's really a lot of the time of our legal specialist is focusing on those kind of problems. I think the gap, perhaps, that exists in the larger framework of the Outer Space Treaty is something that's coming, but in terms of the real problems we're facing today, it's perhaps a couple of steps out, notwithstanding Odyssey and those kind of programs.
Yeah, and let me just follow on. I think number one, first point is that we do, no company's going to argue for more regulation, okay? And I talk about regulation at my own peril, given the financial crisis the last few days, but no company's going to argue for more regulation, but certain things are needed to have a predictable environment to operate in as a company. You need certain legal underpinnings, particularly when you're operating in space, which is, I don't want to say uniquely, but inherently international. I mean, we're launching satellites for companies that are licensed under the ITU to a certain entity. Could be the Isle of Man, could be someone else, and it may be launched by one state, built in another country for an end user in India. I mean, it is inherently an international business with components that are coming from all over the world. And there's no way around that. We're in a global business, and we need certain underpinnings. And what Martin is talking about, I think, is key in terms of, you talk about asset-based financing for a satellite. Same thing if you bought a car, and you need to be able to, the repo man might come and take away. But the reason they're going to give you the reason they're going to give you the loan to take that car is because the law that exists there, that there's an asset there and someone can come and take that. Now, you need a fungible asset to do that, an aircraft, a car. In this case, it would be a spacecraft. To be able to take that spacecraft, someone's going to get the financing for that, be lent the money for that, because on orbit it can be taken and put into another slot and used. You need a fungible asset. So satellites inherently are somewhat built specifically, the beam shapes, the forms, how they're going to serve a certain market. They need to be licensed by a certain entity. They need to be providing service and have partners on the ground in that country. So all those things need to be in place. So what he's doing and what the UNDROP people are doing is important about taking the industry to another step. Now, you can argue all sorts of merit to that, whether or not it works or not. On a more practical level, and bring it back to what Chris was saying, for ITAR regulations, it's something we deal with every day. Do we like it? Obviously it makes our life difficult. We have a team that has to work through the ITAR regulations, but we make it work. But again, the industry is inherently international. You've got, at the fundamental level, if you're going to insure a launch, you've got underwriters with pools of financing coming from around the world, and you need to make sure that those people are comfortable and have access to certain technical data to make sure the rocket's going to work, the satellite's going to function on orbit, that they can provide the insurance capacity to be able to do that. So these are fundamental aspects. In some instances, we actually need these things to be there, to be predictable, and be able to do business. We're not arguing for more, I don't think, by any level, but a clear and predictable regime to be able to do what we need to do.
And I think we have a point from the audience. Thank you.
It's going back a little bit to what you were saying before, because I had the idea a little while ago, was you're talking about commercially going to the moon and mining and stuff. So what's like space heritage law? If eventually, obviously, Odyssey Moon is going to want to send tourism in the far future, but what will be the rules about disturbing like the Apollo landing sites or where rovers have gone, if eventually tourism on Mars and stuff like that?
Well, I guess that's kind of directed at the Odyssey Moon. This is, as you pointed out, is in the realm of maybe what you can't, maybe not so much what you can or can't do, as in what you should or shouldn't do. There is a concept of proprietary that I learned as a young person. I grew up kind of in the country, and you don't mess with other people's stuff unless you have permission. Odyssey Moon has always talked about having a responsible returned to the moon by a private company. And that means that, at least as far as Odyssey Moon goes, we are going to be very respectful to both the assets and the areas that other people, whether they're government or private, and there is a private asset on the moon, we know, because it was purchased from the Russians, whether that be government or private, respect the private property of others. And there's a reciprocal expectation there that when we set down a small robotic lander, we expect to be afforded the same respect. There is a zone of non-interference that really is something that we would like to assert, where if a private company, just like governments before us, were there for peaceful purposes to do scientific exploration, then there's a right to be there and there's a right to operate without interference. So if I'm sending a rover to the moon, I'm not going to do wheelies over Andy Aldrin's dad's footprints. That just wouldn't be cool, and it wouldn't be right, and it might even be illegal. But I think there's a, does that mean that every scrap of metal on the moon is some hallowed ground that can't be touched? I wouldn't think so. So there's sensibility, there's common sense, and eventually, because of the precedents that I think will be set by the first explorers, the lawyers will follow, and case law will be precedent, and that will set the course of the future. I hope that answers the question. And
Bob, on that, all right, part of the Google Lunar X Prize is to go and visit the Apollo landing sites. And from my understanding is there's some people that are very concerned about that. What's the impact of that? Is it hallowed ground? And yeah, common sense makes sense.
I absolutely agree that there, and some Apollo sites more than others. You know, I would say if there's a possibility of having degrees of hallowed ground, you know, Apollo 11 and Apollo 17, first and last, are definitely sacrosanct in my mind. Like, don't go there, or don't go close to there, or don't risk, even if you're having a landing ellipse that could potentially impact it, don't do that. There is a bonus prize within the Google Lunar X Prize framework that provides a bonus for going and photographing heritage hardware, which could be anything from an Apollo landing site to a spent casing of an engine. It doesn't specify what that hardware really is. But some of the people that are saying they will attempt the prize are talking about going back to an Apollo site. And the question, of course, erupts, well, how close are you going to get? And I was involved at the Lunar Science Conference at NASA Ames back in the spring, where this question really did erupt. And what do you guys mean, was the question, and how close are you going to go? I mean, are you going to go take something off and bring it back and sell it on eBay? I mean, that would be very uncool. But not everybody holds this hallowed ground theory as possible. So I think that there is some white papers and some discussion and some frameworks that we all have to agree as human beings of what's cool and what's not, and eventually what's legal and what's not. And we had another question here.
Yes, thank you very much. My name is Peter van Venema. I teach part-time air and space law. And I see some features in the space business and some problems in the space business that airlines don't have to cope with. And one of these is, of course, not so much international law, because you already confirmed that present space law doesn't really interfere that much in your day-to-day business. It may not be ideal, but it doesn't really make that much difference. The only real difference you have is export controls and ITAR. You confirm that repeatedly. That is the real threat which stands in the way of lots of dynamic programs and plans. And my question would be, not only to Clay Mowry but also to the others, what would you do without ITAR? What would you do in the sphere of increasing your business and internationalizing your business without ITAR? Thank you.
I'll have a first stab and just say very briefly that it has a limited impact. Which basically means that they cannot be taken outside of the US and operated outside of the US borders. So for pick any company that's currently developing a suborbital vehicle, it severely limits their operational capability all of the expansion, particularly because the market for space tourism, suborbital space flights is potentially global subject to ICA. It's not just a U.S. phenomenon and just for the U.S. consumer. There is interest from every country in the world, and there are countries knocking on the doors of these suborbital vehicle developers, asking them to come and bring their vehicle to that country. And it's very limiting on those U.S. developers. They're just not in a position to be able to do that. So that's a fairly simplistic, and I'm sure it's the same for some of the other guys as well.
I'll make a brief comment. I'm not sure the question really points in the right direction, because you can say, what if ITAR didn't exist? But there will always be laws that need to be followed. Countries will want to protect their security or their industries or, many other things. So the question is more, when that legislation is being put into force, I think what sometimes gets missed is in the new space world, which is more commercially focused than it has been in the past, what are the impacts of those laws on that world? And is that driving it in contorted ways rather than a straightforward path? So I think it's more a question of ensuring that as new legislation comes in, and if ITAR goes away, something else will replace it, making sure that that doesn't hinder true commercial space. Commercial space, even along the lines of what we see NASA having interest in with the COTS program and programs like that, to be able to open up that new frontier of space, we really need to make sure that the legislation allows it.
Thank you, Tom and Chris, for those returns. I'd like to go to another question, if I could, in the audience here.
Thank you. My name is Frans van der Dunk, University of Nebraska and Black Holes. I want to take it a bit more to the future. I think the beauty of the Outer Space Treaty with a view to private commercial activities in outer space is that states are still responsible and liable for those activities, which has been referred to before, which means that they have to license some way or another and exercise control over those activities. My question to the panel is, to what extent do you see a risk of a phenomenon which in the law of the sea we call flags of convenience, cheap licenses which may put the whole world community at risk?
I think it's absolutely a case. In Virginia, there is legislation, I don't know the exact state of the legislation, that is going in U.S. government philosophy to try to encourage entrepreneurial new businesses and not to overly burden them with requirements, but others would call it flags of convenience, saying that we can get away with doing things that maybe we shouldn't be. But that's just, I think it's an absolute reality. Insurance requirements that the impact, I think, will vehicle operator to carry. And it's designed within, I think...
A good example is the Isle of Man, which has been mentioned here a few times. And I don't think it's, again, so much a flag of convenience as a jurisdiction that's trying to make it easy for companies to do business in space, and having zero tax for space companies, having an ease within which they can enact legislation that will protect those companies. I think that's quite attractive to some, and that's why we're seeing companies set up offices there. Bob, your company has done that.
Absolutely. We chose the Isle of Man for a specific reason. It isn't a flag of convenience. It's a jurisdiction that is stepping up and backing up what they want to do. And we have two and whoever's going to fly that flag, I'm not going to fly under a flag of convenience that isn't going to back it up with the liability consequences that you need to secure yourself and your customers and your investors.
The original example of this was Tongassat. I don't know if people remember the Tongassat example back in the day. And a pure example of this, they went and, because Tonga, as a sovereign nation, could go apply for the slot of the ITU.
But there's a sense, there is not just a sense, but
when you get into
real
international satellite
coordination here.
I always say it's better to be on the side of the country with nuclear weapons. So if you got somebody negotiating your slot for you that's, a major superpower, you're in a lot better position. And I guess for the Isle of Man, you're being negotiated by the government of the United Kingdom, right? At the end of the day, with your ITU priority and your slots. So there is limits, let's say, to how you would do this. There's limits from a legal standpoint and from just a pure practical standpoint.
Right. Responsibility and consequences taken care of. And we have another question in the audience.
Hi, Joanne Gabrinowitz from the University of Mississippi, the National Center for Remote Sensing, Air and Space Law. Actually, it's a quick comment, which is it's very interesting to me to hear there's a consensus saying that the Outer Space Treaty really isn't a day-to-day problem. It shows progress that industry has made, because I think over the years a lot of unsuccessful people have pointed to the treaty as the reason why they couldn't make their business succeed. And I hear maturity here, which is really terrific. Yep. And the other comment is, yes, the Outer Space Treaty is ideal, but it's also very pragmatic. And I'll give you the example. The Soviet Union's position during the negotiations was there could be no private or commercial actors in space, that only nation states were appropriate actors. Article 6 of the Outer Space Treaty is the compromise between the Soviet and the Western position. And the reason why supervision exists is to acknowledge that it is appropriate to have industry and business and commercial activities in space. And so it's really important to understand that you have that general principle, and that's the basis for everything that we're hearing today. That's really pragmatic. Another very pragmatic part of the treaty was the elimination of nuclear weapons and weapons of mass destruction, and I think that's a pretty pragmatic thing.
Thank you very much for pointing that out. Do we have another question? Because I think we have to. Thank you. Okay.
Thank you very much. I am Vladimir Kopal, Professor of International Law at the University of Pilsen, and at the same time I have a very special honor to be Chairman of the Legal Subcommittee of the United Nations Committee on the Peaceful Uses of Outer Space. Therefore, I feel obliged to say something about the space treaties and then my view how to proceed further. First of all, the space treaties under the aegis of the United Nations were concluded not only in 1960s but also in the 1970s. I know it is the past, but compare it, for example, with the development of international air law. The Chicago Convention was concluded in 1944, and later on, of course, other legal measures continued. I believe that the Outer Space Treaty of 1967 is a fair basis and valid basis for further progressive development of space law. And the space law now is a complex system. It's a complex system that is emerging. It means it is based on United Nations space treaties. This is the international legal basis. It is based on provisions in the statutes of international space organizations, such as the Convention of the European Space Agency. It is based on conventions and decisions of the International Telecommunication Union, but at the same time now we have at least 20 countries which have their own national laws, and those national laws, of course, should be in harmony with the foundations of the international space law. It is with the Outer Space Treaty. After all, the Outer Space Treaty is called Principles on Activities of States in Outer Space, so that indeed it is only the basis. And I believe, I fully agree with the view that was just expressed by my good friend Martin Stanford, that there should be further progressive development of space law. The Cape Town Convention is one of the examples in a relatively narrow field, but still it's a good example, and the space protocol that is now under consideration should be, in my conviction, concluded pretty soon in this respect. Thank you very much.
Thank you very much for that comment. And maybe just to wrap this up, I think what we've heard today is that, contrary to maybe what some other sessions in the past may have concluded, the Outer Space Treaty in itself is not some antiquated shackles that is holding commerce and private sector progress back. As a matter of fact, there's progress being made, and that there's the context that there's very solid ground that perhaps that treaty in itself is not standing in the way, because we're coming up with creative ways to responsibly move commerce and private sector out into space. But there are rules and regulations much closer to home that we need today, that we need to deal with every day, whether it's ITAR or it's our own local laws and regulations, and we have to work 11 years through our local government to get to do parabolic flight that a government's been doing for 20 years. So perhaps we've established that we are making real progress here. We've got very stable long-term plans established, and something was written with great foresight in the 1960s and ratified in the 70s that maybe needs to be massaged as we move forward in the solar system. But we really do have rules and regulations right here, right now, that we have to deal with our governments, that of the flags that we're flying or operating under, that we need to work with day by day, and maybe that's where the efforts need to be concentrated. And I do thank very much the panelists for coming today and illuminating us from their perspectives, and particularly the audience and the people who gave us their thoughts and their comments. I really appreciate that. Thank you for coming today. We'll wrap that up. Thank you very much.